Well, welcome everybody. This is Francisco Servent. I am the managing attorney and founder at Keystone Law Firm. All we do is estate planning and administration, some asset protection, and a little bit of business work for our clients. We basically help you protect your family and protect your money so that your family doesn't fight over your money. Today, what I want to share is information about how to take care of your medical decisions when it comes to your estate plan. Medical issues, I mean, holy cow, right? This is the thing that's going to affect you personally the most when it comes to your estate plan. And that's all we're going to cover today. First time I even realized this was an issue was when I was a brand new attorney and this gal came in and she told me she's been married for 30 years, I think, and her husband has, at the time, he has a critical, or not critical, but his dementia had been declining to the point where he no longer could really make all of his decisions, take care of everything. She really had to step in and take over. Really sad situation. He was a very successful, kind of in the technology industry, and he was exposed to Agent Orange in Vietnam, and they are pretty sure it links back to that. And so he was kind of young. He was only about 60 years old. She was a couple years younger than him when she came to my office, and she said that she was told she needed to have medical decision-making authority, make his medical decisions with the doctors and stuff, but that the documents they had done a while ago with their attorney were not being regarded. They weren't being regarded as valid because they were so old, and at the time they were about 10 years old. So the doctors were saying, you need to be legally appointed. These documents are old. You got to get this stuff up to date. Well, when it's time to use these documents, it's too late to update them. And that's what I had to explain to her. So the only thing to do after it's too late is to then go get that permission, get that legal designation from the court. And so I had to explain to her, teach her, take her through the process of getting that permission from the court to literally make decisions for her husband. And it was a nightmare, and it's still going on. It's, I think they're at maybe 10 or 12 years later. This court process has cost that family over $100,000 in fees. Multiple attorneys have gotten involved, and not because anybody's fighting with anybody, but just because the court system is the court system, and it's not based on common sense. It's based on the laws, which, we've all had experience with that, right? And so today I want to share with you guys how to avoid that and how to make sure you can have somebody legally appointed for you, because that's like the key for you. A will and, is important. A trust and everything that happens after you pass away, those are important. My goodness, I can go on and on. But I can promise you that what's going to affect you the most is having somebody you trust make your decisions for you without having to go to court and waste a bunch of time, a bunch of money. Can you imagine not being able to take care of your spouse? Not being able to make decisions for them and tell the doctor, whether you wanted this or that, and she couldn't. She literally has to go to court, and she has to be appointed by the court. So anyway, that's when I first learned about this, and then I since, have done too many of these cases and helped with too many of these clients. All because this stuff isn't done ahead of time and it's not kept up to date. So what she had to go through, what I want you to know about, probably the first thing I would write down if I were you, is that this is called a living probate. That's what happens if you don't fix this, is you end up in a living probate, and it's called a guardianship. You don't want to end up with a guardianship. Those things are super expensive, and I would want you to write down, because I want you to know and remember these things cost anywhere from $10,000 at the least expensive to $80,000 or $90,000 on the other end of the spectrum. They are just insanely expensive, and they can take months and months and months of court hearings and investigators. You're basically like you're with the CPS system, but now it's for adults, and nobody ever accused you of doing anything wrong, but you're kind of in that system. So that's what you're going to avoid by doing all of this. So this living probate, you're going to keep yourself from getting dragged into that by doing 3 documents. If you're married, you're each going to do them. You cannot do this, you can't do one document for the 2 of you. You each have to do your own. So there's 3 documents here. There's a 4th one that I'll mention at the end, I guess as a little bonus, but for the main purpose of what we're going to cover today, it's these 3 documents. And the first one is the healthcare power of attorney. The second one is a HIPAA authorization. And the third one is a living will. Healthcare power of attorney, HIPAA authorization, and living will. So I'm going to talk about each of those and make sure you know what they are. Make sure they make sense to you. You understand them. You kind of get why they're needed and all that kind of stuff. The first one, the healthcare power of attorney. If you're taking notes, I would write healthcare power of attorney, and I would write next to that, it appoints your agent. Okay, that's what it does. It appoints your agent. And that's really critical, because that's the person who's legally designated to do this stuff for you. Now, in Arizona, you can see here on the title of this, it says it says health care power of attorney and mental health power of attorney. And I went ahead and created one for Homer and Marge Simpson, so you could see some examples here. The healthcare power of attorney is one piece. That's to get medical care from a doctor, physician, to get medications and prescriptions. But then Arizona actually separates out the mental health powers. Those are the powers those are the treatment you would get from a neurologist, from a psychiatrist, from a psychologist. Those are the professionals who might treat things like dementia or Alzheimer's on a long-term basis. And so you have to have that extra power in your document, the mental health powers. So like I said, this designates an agent, and you can kind of see how that happens here in my sample document. Now, the way we do it in our firm, we give you the option, and I think this is the best way to do it, is that if you're married, you're going to most likely designate your spouse. If you have a life partner, you've got to do this. You got to designate that person. If you have kids, you're single or whatever, then you designate whoever you want. In our document, this is the one place that I would give you the recommendation that it is okay to designate more than one person to serve jointly. It's okay usually. I've never run into problems with this. Now, if you have a contentious family and you know they're going to disagree, then don't do that. Name one person at a time. You're not making it simpler on them to name them all jointly so that they all can feel like they're included. Trust me, you're not bestowing an honor on them. You're giving them a really tough and ugly job. But if you have if you have family members that can work together, that get along well, then you can name them jointly here, and that's fine. We do see clients will name their kids jointly under this section. But you want to have a primary and you want to have some backups. And on this one, I only have one example backup, Abraham Simpson. You could name another one. You can name 2, 3, 4. You can name however many you want. But just know that you need to be very clear whether somebody is serving jointly and then whether or not people are going to serve one after the other consecutively. Got to be very, very, very clear about that, because you do not want this to be open for interpretation, okay? So you can kind of see what language we use there to do that. Now, the designation of your agent here does not trigger immediately. Okay, this only triggers when and if you are incapacitated, if you need the help. If you're able to communicate to the doctors, if you're able to give instructions, if you're able to, and your instructions are reasonable, you're not, yes, some people can speak, but they can't comprehend what they're saying. If you can comprehend the instructions you're giving, you will always be able to make that decision. But from the moment forward from when you can't understand what decisions need to be made and how to make them, then that's when the agent steps in. That's when it's triggered. And so the agent then is legally appointed to do that, okay? I'm skipping a bunch of these boilerplate kind of legalese sections and just want to show you the other things that you can put in here. You want to describe what your wishes are about long-term or hospice care, whether you want to stay in home, and same thing with maintaining you in a residence, whether you want to stay home and have around-the-clock care come to your home, or whether you're like, no, that's fine, just send me to the old people's resort and have somebody else take care of me. You can put that in here as well. No problems. You can accommodate whatever you want there. But then really what the next most important piece is your wishes regarding your pain care, your pain relief. No matter what, you want to be comfortable and you don't want to be in pain. So you want to make sure you've got some instructions in there about what type of pain relief you want. We also include in this as you're naming your agent as the person who's responsible for your burial or funeral or cremation wishes, whatever your wishes are. And you probably want to go ahead and state that in here. Like in this document, Homer says he directs that his body be buried. If you want to be cremated, you could say cremated. If you want your body donated to science, then you can say that. But you want to have those in there because this is the person who's going to be making those final medical arrangements, towards the end of your life. They're going to be most involved with the hospital or whoever's providing your care, and they'll be the ones that would make the most sense to just carry out your wishes regarding your final disposition. And then there's the mental health powers. We always name the same person for both the medical and the mental health powers. There's no reason to separate that role. And this just carries right through, just specifically covers it. And then we have some other good language in here just to keep your family from fighting about things, what your powers are to serve, and then how the signatures happen. Now, both of these, this document is signed and witnessed by a notary. Okay, then I've created a second set for Marjorie. Yay for Marge Simpson. She's got her own docs, good for her. And then we can move into the second document. I'm gonna actually do the living will last. So the second document I want to cover is your HIPAA authorization. So up top, it's the authorization for release of Homer's protected health information. You can see the HIPAA law cited right in there. This is a absolutely critical document to create separately from your first one, from the healthcare power of attorney. The reason I say that is because your healthcare power of attorney designates the person who can make decisions for you, and it names, first, second, third choices. This document, it does designate people, but they don't have any power to make decisions for you whatsoever. So that's a good thing, because on this list you can put more people. And here we can see that Homer has designated a couple buddies as well. And so on this list is where you're going to name people who can go to the hospital and say, hey, what room is my friend in? Or call the doctor if there's an emergency and say, hey, what's going on? What medication were they on? Because we're at the hospital and we're trying to figure something out. Whatever. These are people who are authorized to receive your information. They're your trusted friends. They're your trusted family members, your trusted loved ones, but they don't necessarily have to be people that you are saying can make your decisions for you, right? They don't have that power. Without them listed on this document, guess what? They call the hospital and they say, hey, what room is mom or dad in? And the hospital has to say, I'm sorry, who are you? We can't release information about our patients unless you're already on file. What's your name? They look them up. If they're not on file, they don't get to know. So make sure that you do this and you include anybody and everybody on this list who you want to be able to have that information. It goes through and just covers more of the HIPAA law. It's a federal law and covers all of that. It's signed and witnessed again by you and a notary. And that's the second document. So that second document, if you if you don't have that and everybody was, say, locked out and unable to find out anything, then that's another reason why you may have to go to that guardianship process. You have to actually file petition in court and say, we think mom is at this hospital. We don't have written authorization. We need written authorization. Can you please designate us? And then the court will decide. We've seen sometimes where they won't designate family. They'll designate a third party and then report back to the court about what they find out. Again, that's part of the living probate process. It's a nightmare. That would cost you tens of thousands of dollars to do that in an emergency. And all you have to do is create that simple document and then not just create it, but keep it up to date over time, because letting these things get out of date is when hospitals and doctors start to feel uncertain, right? They feel uncertain about using something from 10 years ago. Okay, here's the third document that I'm recommending for everybody, is to set up something called a living will. This is absolutely not the same thing as a living trust. Okay, this is a living will. What this document says, or what it does, is it explains your wishes about that end of life decision, and only that end of life decision. So the first document was designating someone to make the decision, as well as all other decisions related to your care. This document says what you want only at the end of life. It doesn't say what you want if you need to go to a nursing home. It doesn't say what you would want over long-term treatment. It just says, hey, if I'm at the end of my life, there it is, if my death becomes imminent, okay? That's what triggers this document. And there's a few different varieties here of what I hear people typically say. Sometimes it'll say, what is said here with Homer Simpson. I don't want to be prolonged, and I don't want life-sustaining treatment. I just want comfort care. I want to die naturally and just administer the medication that is going to keep me comfortable, alleviate my pain. I'm okay if I die. That's what one variety is, what one option is. Some people will say things like, hey, I'm okay with CPR. I'm okay with resuscitation, but I do not want a feeding tube, right? Or you could say, I'm okay with resuscitation. I'm okay with a feeding tube, but I don't want ventilator. So there's a few options there. The one option which we have only used a couple times because it's just rare is the opposite of this one, which is I want my life to be prolonged to the greatest extent possible through all means possible. And that just means they're going to do everything they can to keep you alive, even if you go into a coma, and even if that coma feels long term, they're going to try to keep you alive. And only at the point where your body isn't maintaining the coma despite all of the treatment will they then be forced to let you go. So that's what a living will does. You don't designate anybody in here to carry out this wish. You already did that in your healthcare power of attorney in the first document. This one is just stating your wishes about that end of life decision. And then we do include some language. I recommend you have some language in here about pain relief. You want to be comfortable in that stage of life. You do not want to be in pain. And then it just gets right down into the signature. And again, these are just signed and witnessed by a notary. And again, we have one for Marjorie Simpson right here as well. So if you attended one of my workshops recently where I talked about the State Attorney General of Arizona Life Care Planning Packet, they've created a packet that you can fill in the blanks essentially, sign it, notarize it all on your own. I've seen those. I've even given those to a couple people, but I'm not a big proponent of those, so I just want to highlight for you what the difference is of why it is my law firm doesn't use those forms. The first and biggest reason is because I hate legal documents that even after you're done with them have a bunch of blank lines in them, and that's what they do. They because they have to. It's just a document you download from the internet, and you fill in the blanks, and the blanks you don't use, you leave blank. I just don't like that when it comes to a legal document, especially when it comes to something that's going to be used while you aren't available to tell us what you wanted. And it's scary for me. I've seen circumstances where people have literally completely defrauded the document afterwards, and it's just uncomfortable. So if you're going to use those, just make sure you fill in every blank, you cross out what you're not using, and then I don't even like that because that puts the whole document at risk of being declared invalid. But my recommendation would be to cross out what you're not using, and then the third big reason I'm not a fan of those documents is because you're responsible for getting them signed correctly. And if you get them signed incorrectly, then bam, it's invalid and the whole thing was worthless. And now you're stuck going back through a living probate, spending tens of thousands of dollars and having the court system breathe down your neck every time your family wants to take care of you. So I'm just not a fan of that for that reason. And then the fourth reason is because you get no opportunity to customize it. You either check a box, yes, you leave the box blank, you fill in the blank with your own wording, or you leave it empty, and you can't customize it at all, which means you don't get to create a list of people who have your permission to call the hospital and see what's going on. You only have the ability to say, here's who's making my final decisions, and that's it. So it just is very limited. If that's all you feel like getting done, at least get that done. Maybe it's better than nothing. But we don't use those forms for those reasons. And we use these forms that you're looking at here. Now, some people have also asked us about, and not some people, a lot of people ask us about also creating a DNR. I want to make sure you know what the big difference is between this document, the living will that is on the screen, versus a DNR. So a living will, it deals with a little bit more of a longer term situation than the DNR does. So let me give you the example. A living will works like this. Say you have some massive cardiac event and they shock you and bring you back to life, but you're in a coma. So they take you to the hospital, they get you all hooked up, and they get you stabilized, brain activity, heart, lungs, the organs are working, but you're just in a coma. With a living will, they will shock your heart, they will stabilize you, they'll get you to the hospital, they'll see how you're doing, they'll get all systems stabilized, and they'll wait it out for a few days or however long your family tells them to wait it out. With a living will, though, they won't wait it out forever. They'll wait it out until your family says, okay, enough is enough. A week, 2 weeks, a month, whatever your family feels like enough is enough, that's when they'll remove life support. That's if you have this document, a living will. There's a separate document that's called a DNR. It's on bright orange paper. You can only sign that one with your doctor. And that one says, don't even shock me back to life. It says, if I have a cardiac event, leave me alone, don't touch my body. And that's it. You're dead. That's what a DNR does. It doesn't let them try to resuscitate you and get you stabilized. Now, for some clients, they have a terminal condition and they fought and fought and fought and fought, and they're just done fighting, then that's perfectly fine. They're okay with death. They want to move on. That's what a DNR is for. A living will takes a little bit slower approach. Says, let's see if we can get them back to life, and if we can, then great. We've seen circumstances where somebody has a cardiac event, they shock them, and literally they just poof, they stand back up and they go, whoa, what happened? Well, okay, great. We're back to life. The living will lets them do that. The DNR does not. Okay, so those are the differences. Those are what these documents are. The last thing, actually, let me just kind of wrap those up. So just as a recap, the 3 documents I recommend and I think are critical for every estate plan are the healthcare power of attorney, the HIPAA authorization, and the living will. Okay, so the 3 documents like that are not set up like that with the state attorney general's free packet. They're a little bit different. You have to go through those and figure that out if you want to use those. You're welcome to call our office. We have a little subset where we can just do these 3 documents for you. If you'd like, it's a very reasonable fee. You get to have a consultation with an attorney, and then you'll sign them, correctly with the correct signing, the correct witness, and notary, and it'll be valid, legal, and sealed and done. And you'll take those home as originals, and then they'll also be on file with us. Okay, switch gears a little bit. The 4th document that I recommend for really anybody who's worried about this is something that I don't think I've seen any other firms offer. I don't think I've seen any place you can get forms like this online. We saw this problem come up and we realized we needed to create a solution for it. It's basically an emergency contact, but it's legal. So an emergency legal agent is what is the 4th document. Now, an emergency legal agent, what they are is they are someone designated by you not to really do anything massive or serious or just, nothing like that. They're intended to be your emergency contacts, but in a legal sense, okay? What I like about this document is that you can name anybody who you trust. You don't have to name your trusted people who are going to make your end-of-life decisions or who are going to act as your power of attorney. That's not what the 4th document is for. This 4th document is, hey, I need a couple, and I recommend 3 people who are here, they live close, maybe within 10 or so minutes. They know my family members. At least they know who I communicate with, who I work with, who I'm friends with, so that if I'm with them or they hear about an emergency, they've got my permission to call the hospital, to call my family members, to go to my house and make sure it's secure, to talk to the police if there was an accident. That's all they can do, is basically just get information, secure the house, and notify your loved ones. That's the 4th document. I don't have a sample to show you, but it's called an emergency legal agent. Highly recommend you put that together. Super simple. You basically just pick 3 names and sign it, seal it, notarize it. It's done. We do that for super cheap. I think that's $19. You do it right on our website. You don't even have to come to the office. Super quick and easy. Recommend getting that one done. That closes that gap of the emergency, because what happens here, like with Homer, he has designated Marge, right, as his agent. Well, that's great. That's fine. Well, that's only one person who's allowed because she's got the priority. So the backup people can't go in and do anything. Now, if he also did the HIPAA authorization, he's got that list of people, which is great. But you want a big list of people who can have your permission. And so the emergency people would be able to come in and say, what's going on? Call Marge if she happens to be at work, out of town, or whatever, and notify them that something has happened. The other big piece about your emergency legal agents is we give them a copy of your legal agent document so that they know they're the emergency contacts and they have proof of it in a legal document. That way they can run, show up at the emergency, and be there to help. All right? Now, all of these healthcare documents are good if you keep them up to date. Our firm's recommendation is you don't let them ever get more than 3 years old. But even better yet is that you update them maybe every year, maybe every other year. The last thing you want is for somebody is for a hospital or doctor to reject these when an emergency is unfolding. And then the best practice for storing these documents is going to be to store them up on the Arizona Secretary of State registry. They have a confidential database where they will store it and they will give you a wallet card. And then second, we store these on our secure server for our clients, and you'll have electronic access to those as well. That really is it. Let me give you a little bit more information about our process if you want to learn how to do that with us. All you'll do is you'll email our office with the word team, T-E-A-M, at keystonelawfirm.com. And you'll just say you heard you listened to this web class and you would like to get started to create your medical documents. It's $250. It's a flat fee. You'll get a consultation with an attorney. We'll draft all the documents for you. You'll get to sign and notarize them. And we do have a mobile notary available. There's a little extra charge for that, but it is available if that's something you'd like to do. Our office is in Chandler, and we'll sign those in our office anytime. Super easy to get started. You just, like I said, send that email off, and our staff will get you going. If you just want to start on the emergency legal agent, then you can do that right online. All you do is you go to, and I'm just going to double check that I've got it correct. Let's see. Okay, so it is emergencylegalagent.com. You just go to that website and that'll tell you exactly what to do. You just follow through the steps there, pretty simple, and then you'll get the documents emailed to you for your own signing. And that's it. If you have any questions, you can reach out to that email that I gave you, team@keystonelawfirm.com, or feel free to call our office, 480-209-6942, and we've got some great staff. They'll help you figure out whatever questions you have. They'll help you figure out the answer, whatever process you need to go through next or what your options are. Thanks for watching. I appreciate everybody who takes this stuff seriously, and I look forward to hoping you got some better information today to protect your family, protect your loved ones, and keep them safe from the nasty stuff that happens there in the living probate system. All right, have a great day, guys. Francisco Servant, and I hope this makes sense.